I am Hiroshi Fukurai, professor of sociology and legal studies at the University of California, Santa Cruz, and I teach courses related to history of indigenous nations and peoples, as well as their struggles and resistance against colonial powers, including European colonial now states and historical predation. And living in the United States, my research focuses on the history and impact of English settler colonialism and its transformation into the state system, which now called Los Estados Unidos de America. And essentially, I became the affiliated scholar of the Center for the World Indigenous Studies, which was directed by late doctor and professor, the Rudolf Brizzer, who has worked with many scholars and prominent historians, even geographers. Like I teach at UC Santa Cruz, and for the past 45 years. But Dr. Rudolf Brizzer, whom I call Rudy, has worked with the Barney Nichtman, who was also a prominent UC Berkeley professor for many, many years. And unfortunately, Barney passed away about 20 years ago. And now again, there are a group of scholars, even from the Southwest, worked very closely with the Center for World Indigenous Studies. And also we published some of our very innovative and exploratory ideas in the Fourth World Journal, which was published by this very prominent institution. So for the past 4 or 5 years, we have been working on the creation of a charter called the Charter for the Nations International Criminal Tribunal. Since many of those potential listeners or viewers of this video could be the Spanish speakers. So the name of this NICT, Nations International Criminal Tribunal, is called Tribunal Penal Internacional por las Naciones. So this is quite important because all of us who worked in the creation of a charter understand that the existing international judicial bodies, most importantly, International Court of Justice, we call it ICJ, or ICC, International Criminal Court, which was created by Roma Statute in 1998, and it was implemented and created its court in The Hague, Netherlands, operating since 2002. They only tend to focus on individuals who were suspected of having committed the 4 major crimes, including war crimes, crimes against humanity, crime of aggression, and of course, the genocide. And the major critique being assessed against those wonderful international tribunals and international judicial institution is that they simply focus on individuals. And they fail to look at the collective entities, like responsibility of militias, for instance, and as well as corporate entities that destroy not only indigenous nations and affect their own peoples, but also destroy their ecosystems, eradicate biodiversity, and so on. And also some state agencies act as a predatory entity, even the state itself. So existing judicial institutions lack the capacity, as being written in their own laws, to adjudicate crimes committed by collective agencies. So this NICT not only look at the crimes committed by individuals, but also it has a capacity to investigate and indict and prosecute the crimes committed by collective entities, including militias and corporate entities and state agencies, which are quite innovative. Even though from indigenous point of view, it's not just individuals acted as the violent agents against the lives of indigenous peoples, but also it's a collective militias, agencies created by much bigger organizations, including today large corporations. They have their own military units, privatized agents working on behalf of their own benefit, as well as state agencies. So it's quite important that this charter will look into those aspects and ask the participation by various organizations, regular investigative agencies, as well as active participation by indigenous people. And so those are very crucial aspects of NICT. And if you look into the kinds of penalties assessed and suggested by a charter, they will not seek like a retributive justice, like incarceration of individuals being found guilty of having committed war crimes for 10, 15, 20 years, but rather the punishment was based on the indigenous tradition of restorative justice, such as returning of the stolen lands into the hands of indigenous people, or managing, even with the collaboration of collective agencies, like government agencies, for instance, along with the participation, active participation of indigenous nations and indigenous peoples in trying to preserve biodiversity, which is quite important for the future generations of humanity, as well as other species. So it has very detailed provisions for the options for the restorative justice, and not focusing the punishment just from the retributive justice. And also those adjudicated panels actively call for participation from indigenous nations and peoples. And some of the innovative adaptations that we have incorporated into this chapter is the model developed in Argentina called the Jurado Indígena. In English, it's called the indigenous jury. That is, this adjudicative body will have the half of its members coming from indigenous nations, indigenous communities, and adjudicate together with non-indigenous people. And and also it asks for the half and half parity on the basis of gender identity, because many of the people being affected in the indigenous communities were also women, and the femicide still taking place in indigenous lands as we speak. So the half of the members of this adjudicative body would be women, based on self-identification, of course. And so Charter for NICT has many provisions that have incorporated the indigenous traditions, legal cultures. And so I hope this special issue that will be coming out from Fourth World Journal should be of interest to many people around the globe.